Good evening, Judge May.
Good afternoon, JSC.
It is evening. It's dark outside.
Yes, it
How are
is.
you?
I'm well, thank you, DCJ.
Good. Are you ready to start?
Yes, I'm ready to start.
Thank you.
Good afternoon, Good evening, Commissioners.
You have 3 degrees under your belt, a BA, an LLB, and an LLM. Right?
Yes, I do.
Mm-hmm.
The BA is from UCT, LLB is from UCT, and the LLM is from UWC.
Mm-hmm. You did the first 2 at UCT?
Yes.
And the other one at the Western Cape?
Yes.
Okay. And I see that your thesis aligned with some of the work you do now as a judicial officer,
Yes.
being a Hague network judge, but we'll get to that.
Yes.
Not many people, well, not many judges I know for a fact have this kind of expertise on the bench. You started your legal career in 1996 as a public defender at Legal Aid.
I did.
And then I assume that you did articles because it says here professional assistant.
So my articles, I did a year of
Did your time as public defender count towards that?
Towards my articles, and I did the evening legal school, and that counted for the remainder. And then I did, I qualified, I was admitted as an attorney, and then I was a professional assistant with Y. Bryan & Associates.
But you didn't stay long in that job. You joined the Department of Justice as a family advocate.
Yes, I did.
And you were there for some time.
Yes.
And then went on to you started acting as a magistrate. That was in 2002?
Yes. So my dissertation coincided with the time that I was a family advocate, because that would also be in my area of interest with Hague abductions.
Yes. All right. Then you were permanently appointed as a magistrate in 2003 and worked your way through there, became a senior magistrate in 2019.
Yes.
But then, wait, I'm just trying to follow the chronology here. You were a senior magistrate in 2019.
Yes, I was.
But you had acted in the interim.
Yes. So whilst I was a magistrate...
Acted as a judge, that is.
Yes. I was appointed as an acting judge in the Land Claims Court in 2009 for a period of approximately 17 months. And then I went back to my position as a magistrate. And I had acting stints in between.
Sorry?
I had acting stints in different courts in between.
That they've been in 2011 in the Western Cape, 2013 in the Johannesburg High Court, 2015 in the Free State High Court, back to the Gauteng Division in 2017. And you stayed there until your permanent appointment, finally in 2020.
Yes.
All right, I got that sorted out. Okay, and since your appointment as a High Court judge, you have worked at the LCC, or you started later?
So
I thought you were immediately seconded to that court.
No. I worked as an acting judge in the Land Claims Court, as it was then, in 2021 from April until July.
bringing your acting stint there to what, 20 months?
No, just 3 months.
All right. Have you, we've already mentioned your involvement with the Hague network work.
Yes.
When did you become involved in that aspect of judicial duties?
Sorry, DCJ, can you?
When did you become a Hague network judge? When were you nominated to that position?
So I've been involved in that for the past year.
Or just for the
Yes,
past year?
I've attended conferences since the time that I was a family advocate, and I've attended the family law conferences in that regard as a family advocate and as whilst I was an advocate and as an attorney, and now recently as well. So I've had that interest and I've maintained that interest as well. And I've resumed that interest. So I've maintained that interest consistently in terms of being a network judge, in terms of being interested in children's rights, and in terms of being interested in vulnerable persons, as well as land court issues.
All right. I see that you've written a number of judgments, some of them reported.
Yes.
Any of them written at the Land Claims Court?
So the first one was the Bapiring judgment, and the Farias judgment. And then prior to that, there was a further judgment.
I see that you, at least the ones you've mentioned, you produced during your earlier acting stint.
Yes.
in the early 2000s. Have you written any since you were appointed as a
Yes.
permanent judge?
Yes. So I've written 4 judgments in the last stint. In April to July, there were 5 judgments that were written during that period.
Are those the ones you've listed as being reserved when you completed your...
No. Those reserved judgments have all been handed down. But the judgments in the land claims court that were from April to July, those were handed down some time back.
Yeah. No, you just have not listed, well, as far as I can see, you've not listed a single judgment you've written since your permanent appointment in the Land Claims Court. That's what I was trying to clarify with you.
Oh, okay. So the judgments that I've written in the land claims court are the Sibanyoni judgment, where I dealt with the calculation of cattle. It was a follow-on from a determination of Acting Judge Nkantobi. That was the determination of the... Okay, that was the determination of the value of cattle. Let me just get that, and I will tell you what it is now.
It's fine if you can't find it, Judge Mim.
You can proceed and I'll give it to you shortly, DJ.
Sorry?
I'll give it to you shortly.
Okay.
We can proceed. So the judgments that I have written are the Bhavisha Naransamy versus Ajay Vasaman, and others.
I'm sorry, I'm hard of hearing. I'm struggling to hear you.
Okay.
Would you bring
So
the
it's-
mic closer?
There were 4. The Sibignoni versus Holthausen and others. LCC 143 of 2015. Bhavisha Naransamy versus Ajay Vasaman, NO and others. The third one was the Papalar Borwa Bahaselwani versus Majeje Traditional Authority. And the fourth one was the Zimandi and 129 others versus the Director General of the Department of Rural Development and Land Reform and others. If I can go through those 4 judgments, DCJ. As I indicated, the Sibignoni versus Holthausen, I determined the value of cattle that had been impounded, and it required the determination given the value over time. I determined that the applicant's expert was the expert to follow, and I awarded a sum having regard to the applicant's expert's determination. In the Bhavisha Naransamy matter, that was a matter where it came on review from the magistrate's court, and the magistrate had evicted the occupier, and I'd set aside that eviction on the basis that certain procedural aspects had not been complied with, and the probation officer's report was problematic. The Palaborwa traditional or authority matter, just refresh my memory on that one. Okay, this was a dispute regarding the finalization of land claims between 2 communities. I determined that the dispute was not urgent, and in this particular matter, whilst the issue of cost is normally not determined by the court, I had granted a cost order, as both parties in the matter had successive land claims that had been granted, and both parties still had land claims pending and were both quite successful with previous land claims, and the litigation in this matter could have been resolved amicably. That was the position in that matter. And then the Zimandi matter, this was also a review of the settlement of a land claim. This one is a matter that, after the decision was taken, the applicants brought an application for leave to appeal, which I dismissed. But in this matter, the applicants were given grants in terms of the settlement land acquisition grants. They had purchased the land and through a trust. What had happened was that the trust had gone into difficulties. There was a liquidation application in the North Gauteng High Court. It wasn't defended, and the final liquidation was granted. Subsequent to that, there was a further claim to the same land. And when that claim was lodged, the beneficiaries who were part of the land distribution program sought to bring a claim to the same land. I'd found that they hadn't brought the review timeously, that they hadn't acquired the farm because the trust had acquired the farm, so they weren't beneficiaries in terms of that. And I had dismissed the application. I found that Yes, I dismissed the application and I ordered that each party pay the cost, because both parties, the applicant was pursuing a land right, and it was a constitutional aspect. With regard to what they were pursuing, I was of the view that given that they were legally represented, the issues that they were pursuing was something that was, even if they thought that they were adequately represented the first time, there were still parties who were, they were people of straw, and pursuing the constitutional right with regard to land, it wasn't appropriate to make an order with regard to costs. With regard to the appeal, I had dismissed the application for leave to appeal, and I haven't heard anything with regard to this matter further.
Okay. And these judgments, you say you wrote during your recent stint at the court. Okay.
This was in October 21.
Okay. Have you played any leadership role in any of the courts in which you've sat, either as a magistrate or a judge?
So for the period of February to December 2019 as a senior magistrate. During that period, as a senior magistrate, had supervision over 13 judicial officers, and during that period, I was responsible for the allocation of judicial officers to a particular court. There were 4 domestic violence courts, 4 children's courts, 1 court that dealt with administration of estates, and 3 maintenance courts. And then there was 1 court that dealt with the criminal aspect in terms of the breach of domestic violence protection orders. And apart from the allocation of judicial officers to particular courts, I would also deal with the quality control of the proceedings. So once a matter was finalized, I'd have to peruse the proceedings to determine whether there was a procedural aspect in order to refer it to the High Court if there wasn't an appeal in the matter, or to deal with it in the weekly meetings to bring certain aspects to judicial officers' attention where it wasn't necessarily a matter to refer to for procedural review, but just to address issues of quality control. I'd also deal with training on a weekly basis, and then there were stakeholder meetings with different departments. So with domestic violence, children's court, and maintenance courts, we'd have stakeholder meetings with the prosecutors, Department of Social Services, the Family Advocate's Office, the SAPS, and Home Affairs, to work out how we could ensure the smooth running of the courts, and how to deal with ensuring that the administration of justice ran smoothly. In addition to that, so I said we'd do training on a weekly basis. And then I'd also do reviews with the individual judicial officers to ensure that they were rotating within the different sections, and to work out rotation plans so that they weren't stagnating in one particular section, but that they would work out a rotation period over a period of 2 years to ensure that they were gaining experience in different sections, and to ensure that they enlisted to attend training at the Judicial Education Institute, to ensure that wherever they felt that they required support, they would enroll for the particular training timeously so that we could make arrangements to ensure that there were replacements in the particular courts.
You acted as a judge president in the Land Claims Court.
No, I didn't.
Where did one of the law bodies say that
No.
you did? I think it's Nadel,
No.
so they're mistaken. I looked for it in your CV and I couldn't find it.
Nadel initially confused me with acting Judge President Mead, and then I brought it to their attention that there was an error. So, yes, they
a fair enough
revised that.
mistake to make.
Yes.
All right. Well, you have applied to lead this court. Are there any challenges that you've identified that would need you to address them? Any improvements that you would wish to implement in the running of the court? Just tell us briefly what your view of that court is and what you have in mind for it, if you are appointed.
Thank you, DCJ. So from the time that I've been in that court, I started when Judge President Bam was there, and my recollection, and I understand that Acting Judge President Mead has continued that tradition. It's been consultative, so I think that trend continues. There's consultation with stakeholders, and I think that what I think would assist during the time that I acted in 2021, it was necessary to deal with matters virtually, and I think that has taught us that can continue, and I think that is a necessary step that will see us going forward. Now, I think that still continues to happen, and I think to the extent that the court still needs to be taken to the people, and to the extent that we want to make the court accessible. My view is that this is a court that lends itself to having case lines introduced. I recall us having files delivered and transferred to and fro to the courts and to judges, and I think that the digitization of this court is imperative. So having case lines rolled out, I think, is so necessary, and it would just facilitate the work. And then I think
Okay,
that...
sorry, before you move on, because I'm likely to forget, you mentioned the need for the court to go out to the
Yes.
people.
So let me first start with case lines, because once we have case lines, I think that it just makes it accessible for all legal practitioners everywhere. That's the first aspect. And then in terms of accessibility, the one experience that I had during the COVID period was that there were parties that needed to attend court but could not attend court, so we had it virtually, and they attended at one of the mining companies' offices. And I think that is one of the ways in which the courts can be rolled out in terms of ensuring that matters can be dealt with, not necessarily where the court needs to go out, but where matters can be dealt with online. Where I've had an experience in terms of making the court accessible, in the High Court we've talked about there may be a need to have proceedings made virtual in the same way that these proceedings are live. In the same fashion, court proceedings could be streamed live. So this could be done either in that it is dealt with where it is broadcast to a particular venue, or it is broadcast generally. So if it's a particular venue, that would be where a particular community is impoverished and doesn't have access to resources. But where it is general and there are resources, it could be broadcast, live stream, and people generally would have access. And the fact that it is live stream, it doesn't preclude, it doesn't necessarily mean that only a particular community has access. Any member of the public ought to have access to those proceedings because it is a court of public record. So the fact that it's live streamed means that everybody can have access at any stage. And I think that is important. So that is an aspect that I think is so necessary and would assist greatly and takes the aspect of the way we conduct our courts forward in a particular fashion. The consultation with stakeholders, I think, would also just facilitate, in the way that I've consulted with stakeholders during my time in the district courts. I think the same kind of consultation and the way there was consultation when I was at the land claims court with Judge Bam, I think that also lends itself to addressing problems and ironing problems out. So I think consultation is necessary, and that addresses issues. The challenge that...
Before you move on, can I just take you back to
Yes.
access to the court?
Yes,
Because I know I'm going to forget.
yes.
The previous, I hear what you say about live streaming and about digitization, and I think we all agree with you about the benefits of that mechanism. But the previous candidate highlighted the importance of the court's ability to conduct circuit courts, to go out to communities and conduct proceedings there. And she lamented the fact that because of the current budgetary constraints, the court is not able, or maybe hamstrung in that project going forward. Now, I wanted to find out from you if you agree with that observation, and if you do, what measures you would put in place to ensure that this valuable resource to our people is not lost.
I think the minister has just indicated earlier this year that there are budgetary constraints. So in terms of that, and given that this issue of land is so fundamental, I think that in order to resolve this issue, it's important to ensure that these issues are dealt with, it's accessible, and people can see that it is being addressed. And for that reason, it's necessary to ensure that case lines is rolled out. It's necessary that people have access to the proceedings, whether it is in person or virtually, and that people are accessing proceedings virtually allows for people to realize that they can access proceedings. So I think it is necessary. I think going out to areas in certain, you've got to feel for the particular matters. And in some instances, it may be necessary to go to a particular area depending on a particular matter. It may just be that that particular community requires it. But in other instances, and you can get the feel for that once you've done the case management, and there may be an agreement that the matter is dealt with virtually and that it be live streamed and that there's sufficient access. And I think that can be dealt with on a case-by-case basis. And in that way, cost can be managed. But also, you can deal with addressing a particular community's needs while addressing budgetary constraints. So you're dealing with both aspects. I think it's important in some instances for communities to be able to have that actual contact with the court.
All right, thank you. I'm sorry I interrupted the flow of your presentation. You were still telling us about the improvements you think are necessary to implement in the court.
Yes.
So just carry on. What are the challenges, if any, have you identified?
Okay. So I spoke about having meetings with the stakeholders and addressing issues. I also think that in my experience, there was one researcher. So for one researcher was just overwhelmed with 4 judges requesting or making requests for assistance. So I think that also is an aspect that needs to be addressed. And I think that's the same challenge that we have in the High Court. But I think with this particular court, the issue needs to be addressed particularly because we want to have these issues addressed expeditiously. So I think that is an aspect that is also important, that the court is adequately resourced in order to fulfill the objectives. The other aspect is in terms of addressing all of the matters. I don't think that the current number of judges can deal with the number of matters. So my sense is that mediation ought to play a big role. And when I think about it, historically there were senior practitioners that dealt with matters, and I think that those practitioners ought to be drawn in to do a lot more training and to transfer skills to younger practitioners, whether it's in terms of skills building and in terms of mediation, so that there is that transfer of skills. I think that a lot more needs to be built on in terms of mediation and alternate dispute resolution. And I think that on an ad hoc basis, there needs to be more appointment of acting judges. And I think that the acting judge president has done that on occasion to address the issue of cases that needed to be attended to on an ongoing basis. And I think that that is something that will continue into the future.
Is there anything else you'd like to add?
And I think I've addressed most of the aspects that.
Okay. One law body, I think it's the Law Society, has expressed some misgivings about you ascending to this role at this stage. They think that you might benefit from an acting stint in a leadership role in this court. Would you like to comment on that observation?
I've considered the submissions made by the LSSA as well as another organization. I think it is BLA. I think that the submissions are something that can be considered. I think that when one has regard to the opportunities that are given for women historically, I don't know that women are treated in the same way that men are treated. One doesn't say, well, a man needs to be given an opportunity to act before he's appointed, and I don't know why there's a different standard for men and for women, and why the standard has been introduced now for women. When we transitioned, and it's been a number of years now, we are not a new democracy. It has been a long time that it has taken, and I think that we need to reflect on why we are still saying that we need to give women an opportunity to be trained, and why have those opportunities not arisen as yet? that is a question that we need to reflect on. And yes, when one has regard to the number of years that I've acted as a judge and the number of years that I've been a judicial officer, and one looks at the institutional barriers that one has to overcome, this just seems to be one more. And yes, there are candidates, but my sense is that when the first appointments were made and when my male counterparts were appointed, was there ever a condition that they act in the position first? And I don't know on whether that is a fair and a reasonable distinction that is made. So I consider that, but I think that there is an opportunity, and I think it must be considered in light of what I've submitted and have regard to the history where we've seen women being kept in acting positions for a very long time and not having been appointed.
Well, two other candidates vying for the same post are women. One now sits at the SCA, has long experience in the Land Claims Court, and acted as a deputy judge president for 6 months in the High Court. The other one, appointed to the court not so long ago, but she has written seminal judgments in that court and is actually doing the job of judge president in that court as we speak. Now, why would this commission overlook those candidates?
I'm not saying that the commission must overlook those candidates. I just think that all the candidates need to be considered.
All right.
One needs to look contextually at the candidates, the circumstances. I won't have the same social equity that one particular candidate has, and I wouldn't have the same opportunity that another candidate has. But yes, I have had exposure, and I think that all the candidates must be considered, and it's up to the JSC to decide.
Fair enough. Just for the sake of completeness, because I've raised this with your with the other candidates, you have done a lot of work in the community, particularly in the Women Judges Association, the SAC IWJ, and
Yes.
in Nadel as well. And you mentor young people.
Yes. Yes, I have. So in Nadel, initially, I was on the management and executive committee, and that was really a mentoring of the leaders in Nadel for me as a young woman before I joined the judiciary. So that was a learning experience for me, and that I bring to SAC IAWJ. And then my longest period has been with SAC IAWJ, and I've served in various positions as the secretary, as vice president programs, and back again as a provincial coordinator. And yes, mentorship is an important aspect, and it is, at the moment, there is a program focusing on mentorship of students as well as mentorship on a wider scale of judicial officers and women in the legal profession generally, that is running with the LSSA and UJ and SALA. So yes, that is an aspect that needs to be addressed in terms of leadership, building leadership of women in the judiciary, women in the legal profession.
Thanks, Judge May. I'll now hand over to the acting Judge President of the Land Claims Court to put questions to you if she has any.
Good evening, Judge Mia. Can I just ask you, I have one question for you. Barring your involvement in the IAWJ and your mentoring role, which you've just spoken to us about, can you tell us about, point to specific activities you've engaged in as a judge, which stand you in good stead for the leadership position you have applied for?
So it would be my period as a senior magistrate.
I'm talking about as a judge, since you were appointed as a judge.
So I think by virtue of being a judge, one cultivates the opportunity to be a leader, generally in dealing with a role. So yes, I think that does cultivate leadership skills.
No further questions.
Thanks, AJP. Commissioner Marumachai?
Thank you very much, DCJ. Good evening, Judge.
Good evening, Commissioner Marumachai.
I want to talk to you about a judgment that you just referred to us now, Sibanyoni versus Holt Hazen. That's the one that you just told us that you delivered at the Land Claims Court. You remember that judgment that was dealing with those 6 cattle?
Yes.
Yes. In paragraph 2 of that judgment, you state the issues that must be determined. But I want to take you to paragraph 9, where now you are dealing with experts. I just want to understand, in the context of this judgment, based on the issues that you said they ought, were issues that ought to have been determined in the judgment, as to in what exactly were the 2 experts that you were dealing with expected to give evidence on. That's the first. Secondly, how did you determine that these 2 experts, for both the applicant and the respondent, were experts? And just to give you some guidance as well for the question I'm asking, when you look at the applicant's expert, you are saying that this person has experience in agriculture and livestock production, and that he went to school, in his primary and secondary, he studied agriculture, then he became a lecturer and a principal. But it seems to me when you go down, you're talking about now diseases, foot and mouth disease. It is not clear to me as to in what exactly was this person an expert on, and was this person, because what follows next is determination of the cattle as to how much they weigh and how much they cost. So I'm quite, after I did not read it in depth, I just browsed it through now, and I just want to be fair to you, just to, because you don't even, it doesn't seem to me that you set out the test for an opinion evidence and how you go to an expert and all those. So I'm quite confused as to how you came to a decision that this person was qualified to assist you, but most importantly, assist you in what? That's what I'm concerned about. But if you don't remember the facts, it's fine.
No, I recall the facts. So, as I said, the previous determination in this matter was that there were 6 cattle and the value of the cattle were to be determined. The sum of compensation for the 6 cattle were to be determined. And the second aspect was that the parties, this had been agreed, that the parties would file reports in that regard. So the applicant filed an expert witness and then the respondent filed an expert witness. The applicant's expert witness summary was filed, and the respondent didn't file an expert summary witness, a summary statement. There was an objection when the matter appeared before me, and that is why I addressed that particular issue in terms of the background, and I compared the background of the 2 experts. The applicant's expert, I gave his background in terms of why I believed he was an expert and why he was able to tell me about the cattle. So when you are determining the value of the cattle, you need to know what type of cattle it is. And because these cattle were impounded, there was an assumption that they wouldn't be cattle of value according to the pound master or the auctioneer. So the auctioneer was called as an expert. The auctioneer was a legal practitioner who had been running an auctioneer's business for
But that is for the respondent, right?
For the respondent.
Yes. I was more concerned, I mean, that can be a question on its own. I was more concerned on the applicant's expert, yes.
So the applicant's expert was trained in agriculture in terms of raising cattle, in terms of dealing with, so one of the aspects was if the cattle had disease, then there wouldn't be value. But if there wasn't disease in that particular area, it wouldn't affect the value of the cattle. So the suggestion that that would reduce the value of the cattle because it belonged to a tenant, that was introduced as an argument. And the applicant's expert was able, because he had knowledge in the area, and he traveled around in that area because he worked for the department and he was required to visit farms in the area. He had knowledge about whether there was disease in the area in that particular year, and he was able to indicate that there wasn't disease, and that is why he believed that the cattle were not tainted or they were quality cattle.
Okay. No, so sorry, can I just follow up on this? Yes. I sympathize with that, but I think my concern is I don't feel like it's being addressed. Let me ask you a direct question.
Yes.
What is a test that you use to determine that a particular individual, because opinion evidence, I mean, it goes like this, it's either expert or lay,
Qualification.
and there can be something in between where somebody, like maybe a traditional healer in a village that did not study anything, but has, through experience has gained expertise and all those kind of things. So, because I just want to understand, what is then the test that you use to say this person is an expert and is qualified to guide me to come to a particular determination or understand the facts better? What is the actual test for because it doesn't seem like you are stating it. Now we leave it there, DCJ.
Okay, let me just have regard to this. I addressed it in terms of saying that the expert witness must have knowledge.
I'm sorry, Judge
about
Mia,
the
you're
particular-
speaking away from the
Oh, sorry.
mic.
I addressed it in terms of the expert must have knowledge about a particular aspect that he or she is testifying about. This particular witness did have knowledge and had qualifications, had studied on that particular area, and had experience in terms of practical experience after having studied in that particular area. So it was practical knowledge as well as experiential knowledge. So it was theoretical, practical, and experiential knowledge.
I will leave it there, Judge Maya. Thank you very much. Thank you very much, DCJ.
Thanks, Commissioner Marumachai. Are there any questions for this candidate from the virtual platform?
No, thank you, Deputy Chief Justice.
Thank you. Judge Mee, we don't have any further questions for you. Do you want to ask us anything?
No, I'm good. Thank you, DCJ.
All right, thanks. Oh, I
Thank you,
forgot to
Commissioners.
apologize to you earlier for keeping you waiting.
No problem.
Please forgive us, and thank you so much for making yourself available for this vacancy.
Thank you,
You're
DCJ and
excused.
Commissioners.